I have before me a plea form that indicates the defendant will be pleading to an added count.
This is where the deal starts taking shape. One charge gets added, another dropped. That's the legal trade-off. But here's the real question. Is the defendant minimizing damage or locking himself into something worse later?
To use of cocaine, the 1 year offense, found a successful plea of that charge, count one would be dismissed. There is a sentence agreement, credit for time served, and fines and costs. That's the court's full understanding of the.
Correct, Your Honor.
That's correct, John. May have him sworn.
Solemnly swear to affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name, please.
Sir, Bush, Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of cocaine. That's a misdemeanor, punishable by up to 1 year incarceration and a $2,000 fine plus court costs. You understand that?
Microphone VO number 2. And just like that, guilty. That single word wipes out the chance of a trial. No jury, no defense arguments. Do you think he fully grasped how much he just gave up in that moment?
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th.
Okay.
Understand that? Understanding all of that, do you still wish to plead guilty?
Yes, sir.
To that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
Signed an advice of rights form or had one signed on your behalf. Is that correct, sir? Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights.
Yes, sir.
You understand you're giving up your right to appeal love right?
Yes, sir.
Are you on probation or parole?
No.
Anybody promised you anything other than what's been stated here today to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And because you believe that you are indeed guilty?
Yes, sir.
September 22nd, 2026, at the location of 100 South 4th Street, City of Ann Arbor, Washtenaw County, State of Michigan. Did you have cocaine in your possession? Had you used it?
Yes, sir.
Did you know what you were using was cocaine? All right. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in court rules, would not be entitled to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. You understand that? Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor. And have I complied with the court?
You are satisfied.
Yes, Your Honor. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Probation sentencing in this matter will be May 8th, 2026, 8:30 before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case of the people versus Plea.
This warning is huge. One mistake before sentencing and the entire deal could collapse. No second chances, no easy exit. Now everything depends on what happens next and how the judge sees it.
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Bird.
Hello, good morning. Morning, your name? John Bird. Thank you. What do we do?
Your Honor, I did reach out to Ms. Linda because we did not receive discovery in this matter. I have since spoken with Mr. Bird, who states this is a reauthorization case. So I did, both are. So I did go back to look through our file, and I cannot confirm for one of the cases that we did represent them. I believe my understanding that we did was in terms of looking through the file and matching the dates that these have alleged to have occurred. So that's the first thing.
Just so I'm clear, what you're telling me is that you may not have discovered this record on one of these.
Only procedure. It was resent for both files. You didn't realize it was the same. Yesterday.
Got it. Oh,
Still not in my file as of last night when we met. I will check again. I have not checked this morning. So I am asking for some time for that, but I would also like to address bond. And if I could have
Oh.
one moment.
So if you're gonna get the discovery, here's what I want to also make sure of. I don't mind adjourning it out, doing that, but I want to make sure if Mr. Bird's indicating that on the previous one, the public defender representative is not going to be an issue. What I would like not to run into, if we can avoid it, is all of a sudden you're here on both cases, but now you have a conflict. It's put out and then
Yes.
further delayed.
That
But we don't know that.
I do not believe that we have a conflict just based on my review of our representation of him in the past,
Got it.
and that it's
Oh.
the same complainant.
Oh,
Currently, or pardon me, we very recently represented him on a probation violation involving the same person.
oh. Then I'll adjourn this out to May 2nd.
You know, I was going to say, could we have a shorter period of time, and I will explain that part. Even
Go ahead.
even just a week would be fine. That is because Mr. Bird is the complainant in a matter involving this same complaining witness. This is a 2024 case. There is currently a matter where he is the victim, and this morning I was able to find that case and make copies of the register of actions for both Your Honor and the prosecutor. And he has been attending all of those court dates, but there is a concern that part of this case was dismissed in 2024. And I was able to confirm, as my client told me, that just before the meeting with the friend of the court in their divorce custody proceeding, that the complainant came to the Washtenaw County Prosecutor's Office almost 2 years later, asking to have the matter reauthorized. As it states in the report, that does not mean it's not any less serious, but it is an interesting state of affairs. And he has a pretrial on the matter where he's the victim. He's been attending each of the case, all of the
Case.
That is in Wayne County, and that is on May 8th. And like I said, I was able to print that out for Your Honor and the prosecutor this morning when I put it.
Yeah, I want to say for the record, I spoke with the victim myself before we authorized these cases, and she indicated to us that at the time these cases were dismissed, she was extremely horrified with them and was not comfortable proceeding. She now has a better support system around her, and he had continued to harass her in the time since these cases were dismissed, and now she felt more comfortable proceeding, and that is why these cases are now back before her.
I also have, and I did not, because I'm not trying to retry the custody case, but I do have the recommendation where she speaks about what a great father he is and all of those things. So I wanted to
That's trouble made.
you
Right?
can be,
That's it. So I don't know what that has to do with it.
but my
I'm not a family court, so I don't know what
Yeah.
that means.
But my point being is that I'm only trying to address these as far as bond, and to have court date next week so that he will be available to go to the pretrial hearing for the case where she hit him with her car.
Allegedly.
Allegedly.
Thank you.
Yes, yes.
So
Well,
that's set for the A.
that is set for the 8th. So if we could have a 1-week adjournment.
Yeah. Any objection to
Yeah, we decided that yesterday, so we should have everything.
We'll adjourn it 1 week out to the 30th.
And Your Honor, we would ask that the court, considering how old this case is, in that in terms of since that case was dismissed in 2024, there have not been any allegations or cases as far as Mr. Bird The only cases have been I believe there are two, but definitely this one pending, where Mr. Bird is allegedly the victim. And so with that, I believe that he can abide by any orders, no contact orders, or whatever the court would say would be appropriate, so that he can continue to not only pursue this case, but also his rights as related to being a victim in the other case. And so we're asking for personal recovery.
Bones.
You know, Judge, this is two cases of aggravated assault. These cases includes threats to the victim that include the defendant texting her. If I see you in his feet, I'm mocking you, bitch. Don't be hollow. You make learn to keep my name out of your mouth. That he will. One the victim powerful will be hit. And then if he does to us, she informed us in this hey, walk for measures for going through the related report, in which he was still continuing to harass her, showing up to her unit unannounced and calling her, looking at herself in the vehicle. And that is why this case is done. So I don't consider the person that even when the punishments that had her harassed, they continue to have concerns.
You know, there's no allegations of any of those things since 2024. These are allegations from that case from 2024. We have not had any cases come forth. Pardon me?
That's not what I'm hearing.
December of 2025, that wasn't a different case that I somehow made it added onto this one as a related report. That includes allegations of him coming to our unit in 2025, December of 2025, and continuing to harass. So I would add that in.
Your Honor, that was after those other matters were dismissed, and there continue to be parents together. But if the court implements an order, a no contact order, then he will abide by that order.
Yes, since I'm adjourning it out for 1 week. 30th. I'll just adjourn it out there. At this point, I'm going to deny the motion for bond reduction or modification of bond. Let you take a look at that in the report, see whether or not that other report is your will. Your bond argument.
Thank you.
Thank you.
Gentlemen, on behalf of Miss Olive in case number ending in 1321. Your Honor, Mr. Kolovos was here. He is representing Miss Olive on the other case. However, I was informed this morning that he is taking over my case as well. I believe he filed an appearance. He has asked me to stand in on these matters.
Well, he'd have to file a substitution, first of all.
I understand, Your Honor. I'm working with what I have here.
That's the call of my given day, or any day for me.
So,
All right. So I'm looking for an adjournment.
I know that I had Mr. Kolovos fill out a couple of green sheets. I believe you have those in both files.
Did have the green sheets.
Yeah.
Mr. Cloaks was here.
Where'd he go?
He indicated. He told him if
He had to go someplace else. The judge said if he didn't go there.
correct.
So what am I supposed to do?
Apparently not
I'm-
exact.
I'm kind of inconsiderate, Judge.
Your Honor, on
I'm
behalf
going to change that whole.
of Miss Olive, I'm here and I'm happy to see you.
No, I'm not. Miss Allen is. You understand? What's his name? Clovis.
Kolovos?
He's going to be representing you on the both matters. Is that your understanding?
Sir.
All right. Do you have any, for the purposes of an adjournment today, do you have any objection to Mr. Almond stepping in?
No, sir.
All right. Thank you. All right. Did he indicate to you as he headed off to the other judge that he likes more? How much time he'd need?
No, Your Honor. I believe maybe sometime in what early May date, maybe mid-May would be fine. I don't know.
Yeah, I spoke to Mr. Cole this morning, so I don't want to quote. Fortunately, I think that they're going to be close to a waiver view. We need to retrieve the suit and give this.
Are these the only cases holding you, lady?
Yes, sir.
That,
You don't check her. She has,
I'm done with
probationary matter.
oh, she's serving time on probation violation. All right, then I'll adjourn it to May 7th.
Thank you, Your Honor.
Both matters. 4699. All right,
Thank you, Your Honor.
thank you.
That's it for me. Have a good day. That's it.
Here. Yeah. No, I'm kidding.